Hey everybody, how you doing? As you Ann just said, John J.R. Richards here, and I'm looking over the list of attendees, and I really wish we were in person. So many great people are here for this event. We're really glad and welcome you here. It was kind of we did a little experiment. We did a DoorDash lunch where if you signed up, you got a DoorDash coupon to be able to order lunch while you were here. So it's not quite Scott's, but we're giving our best to have a great presentation. And today it's my pleasure to introduce three speakers for a really, really important topic. Obviously, landlord tenant, there's a lot of changes with the law and a lot of uncertainty. And we're really looking forward to hearing from Judge Jennifer Lee, Department 25. She's a sitting judge here in Contra Costa County. She's probably going to give a little wave here. Yeah, no wave, but oh, there we go. And Commissioner Palvir Shoker from Pittsburgh, currently sitting commissioner in Department 50 in Pittsburgh. And anybody who's done a UD in Contra Costa County would also recognize our other speaker, Deborah Levy. By the way, you're muted right now, Deborah. So
I do know that.
Okay, good. So Deborah has been instrumental in doing the volunteer mediation program here in Contra Costa for a long time. I know that any of the judges that are working in UDs really appreciate the work that she and the other mediators do. So we're going to start off initially with Deborah talking about volunteer opportunities here in Contra Costa related to, I believe, unlawful detainers. And then we'll get into the actual presentation. If you have questions, we received questions ahead of time. You can put them in the chat. You can put them in the Q&A. I will do my best to get to every single question and articulate them to our speakers. And they will be taken at the end. We are, the plan is for everything to end at 1 o'clock, and then we'll take 15 minutes for questions. Anyway, I'm going to hand it over to Deborah now, who's going to give us, as I said, some information about volunteer opportunities.
Great. Thank you, Don. Okay, let me tell you a little bit about how the Congress of Neutrals positively impacts litigants and the work you as attorneys do in taking cases to court. I'm also going to tell you a little about some of our newly funded programs that the Congress is overseeing and how you can be a part of it. So just a little history on the Congress. We have been established, we were established back in 2000 and began to provide small claims mediation services for the Contra Costa County Superior Court. Since then, we've expanded our services in the court and have also been providing mediation and services to the 3 courthouse civil harassment and unlawful detainer calendars, as well as mediating family law contempt cases. So the Congress has also been a community leader in 40-hour training mediation trainings. And we have an upcoming training this spring, beginning April 21st, 2022. So it's going to be a hybrid model. It'll be 3 sessions on Zoom, 2 in person, of course, taking into account all COVID protocol. So the certificate will provide people with the opportunity to mediate in courts and launch even your own mediation practice. So the program will be taught by attorneys and mediators whom have many years of training, instructional, and mediation experience. So we're going to have signups available on the website. Also, individuals who have completed a 40-hour mediation training can continue to build skills and become involved in the Superior Court's mediation program. And this is a great opportunity to get hands-on mediation experience. So we're really one of the only organizations that does provide this kind of opportunity in the Bay Area. And we often draw mediators who have recently completed trainings and who are looking for experiences. The advantages are multifold. You get an opportunity to practice your skills under trained mediators. For those that are new to the legal profession or not in court too often, or even interested in the areas of unlawful detainer or civil harassment law, you get experience with these issues, how to mediate the cases, and even the event that we don't settle a case, it's an opportunity to listen to the case in court. So those who are interested in becoming involved can sign up with our mediator mentoring program, where we schedule a 6-session training in the courts. When you're done, you'll be leading mediations. Again, more information will be available on the website, and I'll leave my contact information in the chat. if you're interested as well. We're looking for mediators in each of the calendars in the court, whether it be small claims, unlawful detainers, or civil harassment restraining orders. So I'd like to turn to a newly funded program that's come out of the County Board of Supervisors' concerns about post-eviction moratorium court cases. So in response to what we thought would be a flood of eviction cases, a program that's been was actually established in conjunction with the pro bono committee of our bar association here, was set up to provide limited scope legal unlawful detainer advice to litigants on either the day of trial, issue conference, or even prior to an appearance. So you may have seen these emailings go out, and they were sent out by the Bar Association back in October of 2021. So unfortunately, we found that it's been difficult to recruit attorneys to take on a few hours of the day to drive out to court for this pro bono opportunity, not to mention that COVID and the Omicron variant are making people more skeptical about, unnecessary face-to-face interactions. So trying to come up with a solution. So we want to keep you safe while providing a valuable pro bono service to the community. So we are now recruiting attorneys to make themselves available by phone, by email, or even Zoom on one of the 6 unlawful detainer calendars that are heard in the county during the week. So probably most of you know this, but these take place on Tuesday and Thursday mornings from about 9 a.m. to noon, in the afternoons from approximately 1 to 4, and on Wednesday and Friday afternoons from about 1:30 to 4:30. And since it'll be virtual for you, you don't need to drive out to any of the courthouses. We are asking that you simply be able to sign up for one of those dates to answer legal questions by litigants. Again, there's no legal representation during court proceedings, and litigants must consent to a waiver of liability. There's no attorney-client relationship established by assisting these litigants. So we're also going to have signups available on the website, on our website. I encourage you to email me if you're interested. You can sign up for this twice a month, once a month, or weekly. And again, contact me if you have any further questions. So we're going to forward that information to you. Unfortunately, our website is under redevelopment right now, so we're in a little bit of a glitch, and I'm going to resend out information about that once we get our website fully operational again. So I also want to make you aware of another program that we've partnered with, Shelter Inc., which is, many of you don't know that it's one of the biggest nonprofits in dealing with homelessness issues in this area. And they are helping staff a legal resource and referral clinic to litigants on each of the unlawful detainer calendars. So this is also in response to the post-eviction moratorium concerns. The clinic staff help refer litigants to community resources and help litigants with some of the court paperwork. They are housed in each of the 3, like I said, each of the 3 clinics, they're 3 courthouses, I'm sorry, during the unlawful detainer calendars. So we just want you to know that they're not legally trained individuals, so their assistance is not legal in nature, and litigants must answer all the questions without assistance. So as mediators, we really strive to find solutions to the cases that you bring to court. And I want you to know it's very gratifying to know that both parties' needs can be met through compromise. I do hope to hear from many of you regarding volunteer opportunities, even for just a couple hours per month with the Attorney of the Day program, or even considering getting involved with the mediation through our upcoming training or with our mediation mentoring program. So thank you very much. I'll hand it back to John. If anyone has any questions, you can chat it to me, or please send me an email.
Great. I'm simply going to hand it over to Judge Jennifer Lee.
Good afternoon, everyone, and thank you all so much. Some of you may recall that I was sitting as the commissioner for unlawful detainers, and I have happily turned that over to our new commissioner, Commissioner Shoker. It was so well deserved, and we're so honored and grateful to have her presiding over these unlawful detainers. The presentation today is just going to be a high-level overview of the current law. As most of you are aware, as bench officers, we can't give you any legal advice. We also can't tell you how a court would rule on any particular issue, but this is just sort of a high level of what's going on right now, as opposed to what was going on in the past. And we're happy to answer any questions that you may have if we are able to. So get this PowerPoint to work. So back in 2019, once upon a time, before COVID, evictions worked a lot like this. There'd be the 3-day notice to pay or quit. A complaint and a summons was filed. The tenant may or may not file an answer, but for this exercise, they file an answer. There'd be a trial. The defendant would be found guilty of an unlawful detainer. There'd be post-trial motions, if any, and there'd be a writ and a lockout. And we're focusing mostly on the 3-day notice to pay or quit in this presentation because that's where it seems to be. The notice to pay or quit is where it's been the bulk of the issues as we've been in this COVID period. But that was how it used to be. Pretty straightforward, right out of the code. Nothing really particularly complicated in terms of what the requirements were. The facts, that's a different story, but that's not what's relevant for this. Now let's talk about the COVID years.
And just because we said once upon a time, this story is not going to have a happily ever after.
Thank you.
Just giving heads up if somebody's expecting that.
Yes, there's no happily ever after. I 100% agree. So for the COVID years, the protected period, if many of you may remember, that the governor signed the moratorium, and I use the word moratorium, but it's actually a misnomer. There was no 100% moratorium on evictions. There was a limitation on evictions. The word moratorium got bandied about so often that it created a lot of confusion. It's not, there was never a moratorium. It was always a limitation on evictions. But the protected period originally was from March 1st to August 31st. And of 2020, and AB 3088 required a now 15-day notice to pay or quit. And all the tenant had to do, if they were not a high income earner, was file a declaration of COVID distress under penalty of perjury. And that was it. That was all they had to do. And the landlord would have been able to seek back rent in small claims court. At the time, it wasn't effective November 1st. At the time, it was effective. Originally, it was in September of 2021, and then it just kept moving. But we put November 1st because that's the new date that people can seek back rent for this protected period. This is a protected period where landlords were the only recourse they have to seek back rent for this period is through small claims. Or ERAP, but it can't be part of, it could not be part of any judgment. So that was the original AB 3088. And the declaration of COVID financial distress didn't precluded a landlord from, or an attorney from questioning or challenging that declaration unless there was evidence, unless it was a high income earner. That was the only time. But in the majority of cases, that wasn't an issue. So then we move on to September 1st, 2020 to December 30th, 2021. It was still a 15-day notice to pay or quit. And originally, the small claims cases that moved from, that were going to allow recovery in March of 2021, then moved to July of 2021, and then moved to October of 2021, and are now November of 2020, beginning November 2021. But AB 832 extended the protections under that had been in effect under AB 3088 and SB 91. It extended those protections until September 30th. It required a 15-day notice to pay or quit. Same thing if a tenant signed a declaration of COVID-19 financial distress, that would stop the case. However, for this period of time from September 1st to September 30th, the tenant was required to pay 25% of the landlord, of all the rent to the landlord by September 30th, 2021. And ERAP was now available for 100% of the debt. Before it was only 80%. So before they had the extension under AB 832, under SB 91, it would cover 80%. And then once the governor decided that everyone who had COVID related financial distress would be eligible to have all of the back rent paid. If they qualified, it now took away that 25%, which created a little bit of confusion, because if they didn't pay the 25%, how are they now eligible for 100%? Or if they did pay the 25%, what are they really eligible for? And how does that get offset? So there are key definitions that are really important, because COVID rental debt is defined differently. COVID-19 rental debt, defined under CCP 1179.02A and C and 1179.09C, is unpaid rent or any other unpaid financial obligation of the tenant under the tenancy that came due between March 1st, 2020 and September 30th, 2021. But then rental, so that's the debt that can only be reclaimed through small claims court. Then there's the rental or ERAP, the rental recovery period. I'm sorry, the recovery period rental debt is rental debt of a tenant under a tenancy that came due between October 1st, 2021 and March 30th, 2022. And that's now the new amended 1179.09B. And that rental debt that accumulated due to COVID financial hardship is defined as COVID rental debt. So going back to the original definition from March 1st through September 30th, 2021. And COVID-19 recovery period rental debt, which goes to October 1st, 2021 and March 30th, 2022, or a combination of both, if it accumulated during a tenancy initially established before October 1st, 2021. So there's all these different definitions, and it's important to know each one, because as you'll see, each one has different rules. It depends on when the money came due. So Commissioner Shoker, why don't we go through, why don't you take the helm?
And before we get carried away with everything that we've prepared, if somebody's having panic attacks and this is the first time they're really coming face to face, please don't worry. We all have been in the same boat. And in fact, people who have been doing it for many years, they're kind of marking March 31st on their calendars, because they're hoping that that's the end of this.
Write it in pencil.
Write it in pencil. That's what I keep telling people, write it in pencil. Not that we have any information, but we don't know, given what happened the last 2 years. So obviously, we've gone through the protected period, transition period. So now we are in recovery period, and I want to put a big asterisk next to it, because I don't know what to call if it gets extended after March 31st. So this is where the way we define it is that right now that the rents that are not based on non-payment of rent, they go back to the pre-COVID timelines, so which was 3 days, and only just cause evictions. This is an area where, if we're not going into detail in the CC 1946.2, but I would say take a look at it, because for many people, this is still a new area, and there's still questions as to what is just cause eviction. But that's for another date. But for now, as far as COVID rent and all that is concerned, if it's a non-payment of rent, we go back to 3 days. And if it's based on non-payment of rent, then obviously the following requirements: it's a residential UD, failure to pay rent due to COVID-19 hardship. And yes, there's an asterisk next to it. We can touch upon that a little bit. And then NTQ, notice to quit, reverts back to 3 days, and must have the verbiage that's in CCP 1179.10. Going back,
I'm sorry.
1 moment. Going back to that asterisk, the only reason, again, you guys know more than we do. We just get to hear what you're bringing before us, but there might be case law here as to what's the definition of COVID-19 hardship. We don't know that, but that's why that asterisk is there, that maybe people smarter than myself can come up with what's the definition of that. And if somebody doesn't meet that definition, then do they have to abide by the rest of the requirements? Let's go to the next slide. So the way we're looking at UD cases is when you come to file the case, because even the filing clerks, they had to be retrained, they had to learn everything. So from their perspective, and from our perspective as well, we split that into the summons stage, where you're just coming in, somebody's coming in, landlord is just coming off the street, is trying to file something. So what are the requirements now for the summons to be issued? Landlord completed an application for rental assistance and a copy of the denial is attached, or one of the followings. 20 days have passed since the later of either the date the plaintiff or landlord completed the application and the date the landlord served the tenant 3-day notice. And the landlord has not received notice from rental assistance program that the tenant has completed the application, and the landlord has not received any communication from the tenant. Or rental debt is from a tenancy created after October 1st, 2021. Again, my read on that is that it's an actual new tenancy, not a renewal, not renewing the lease. It has to be a brand new tenancy. If it is, then you don't check any of those boxes, and summons can be issued. So for that, UD 101 must be filed. This is where, going back to what Deborah was saying, we have clinics available. Clinics are at least in Pittsburgh location, when there is clinic, it's open to landlords and tenants, because landlords coming in don't know that there are new forms. They might have forms from a couple of years ago. So there are new forms. So for summons, UD 101 has to be filed. Let's go to the next screen. Did we miss it?
Yeah, I'm just trying to get it to go. There we go.
Okay. So on this one, we're just, again, going back to definition in this. So we are still in the recovery period, October 1st through March 31st. So just a recap, 15-day or 3-day notice to pay. So the reason we added both is if it's a combination. What if you have rent, some of that is due from the transition period and the remaining is in the recovery period. So does the 15-day apply or does the 3-day apply? And that's why there's an asterisk that if the debt is from, or the back rent is from the transition period, then obviously what Commissioner Judge Lee had covered, it was 15 days, but now it's back to 3 days. So do the landlords have to serve both, or can one 15-day notice cover both periods? Again, I cannot tell you which way you need to go. I can just tell you what our reading is. Just as a common sense thing, I would think 15 is bigger than 3. So if you do 15, it covers a 3, but that's just me throwing that out there.
What's important to note is that the law, the AB 3088 changes, AB 3088, SB 91 and 832, everything before October 1st, when the legislatures decided to change everything again with 1179, they kept intact the period from March 30, the rules from March 1st, 2020 to September 30th, 2021. They didn't repeal those code sections or modify them. So they're still valid. That's why if you have to look at if it's a combination, what does each separate payment, where does it fall? And under what code section would it fall? What period is covered? And then I'll just be frank, it would have been a lot easier if they had reconciled the statutes, but they didn't. And I'm not a legislature, but that's the reality of it, is that they weren't reconciled to make it clear what notice was. So, look at each code section for each rental debt period and make sure that those notices are the appropriate notices. But Commissioner Shoker is right. There may be an argument that 15 days being longer than 3 days, it doesn't hurt if you include it in one. And I'm sorry, I didn't mean to interrupt you. I mean, I did mean to interrupt you, but I apologize for interrupting you.
That's why we're going through this, because we all in this together. We all kind of trying to go through these statutes and see, if they repeal something or what language was added So that's what we're trying to, I keep using the word cheat sheet when I'm talking to people here, that this is our cheat sheet. So this is our cheat sheet to figure out if summons can be issued. So I think the bottom line is that the landlord has to provide proof that either they applied for ERAP, got denied, or the tenant hasn't applied, or they haven't heard anything back. So that has to be included for the summons to be issued. Next slide.
All right.
So again, during this period, the default judgments are going through, but there are obviously additional things that needs to happen. So 3-day notice to pay or quit must have language consistent with CCP 1179.10. Landlord must state applied for ERAP before filing the complaint. ERAP was denied, lack of eligibility or lack of funding, or tenant's portion of the application remains incomplete for 15 business days after landlord applied and completed the application. If before landlord has the possession, tenant files for verification that ERAP has been approved, court will stay the proceeding and have a hearing on it. So this is where the UD 120 issue comes in, and this is, we see these applications, they act like a stay on the case, but it has to be approved. So many times we'll have circumstances where application is still showing up as pending. We have access to that number. We're, as judicial officers, we can call that number and get the status that day. However, if we don't have that ID number, that the tenant number, or from landlord, if we don't have that, we cannot call the 800 number because we don't have anything to give them. So if the case has been stayed and we set it for a hearing, that's when we determine if the case will remain stayed, meaning the application has been approved, they're just waiting for the funds, or if it's just pending. And if it's pending, you know, the case will move forward. At that point, the stay gets lifted, case will move forward, but that doesn't mean the tenant won't file another UD 125 as soon as the application is approved. Again, when I talk about these forms, just all these forms have to be current forms, the current version of the UD 125. Yes, it shouldn't technically be such a big deal that if it's an outdated form, but there is information in the new forms that are not in the older forms. So that's why we kind of keep highlighting these, that they use the most current updated forms.
So we made sort of like another flow chart.
Yeah, as I said, we keep going back to our little charts, and I think I have them all around my office as well, my quick cheat sheet things. So go ahead.
Oh, no, I was gonna say just for filed after October 1st, 2021.
Yeah, no, go for it.
Oh, so for non-payment of rent between March 1st, 2020 and September 30th, 2021, the 15-day notice to pay or quit still applies under CCP 1179.03 and 1179.11. And that also means it requires the same verbiage. All those requirements are, so you have to still follow that code section, along with all the mandatory forms that have been put in place and so on and so forth. Non-payment of rent after March 1st, 2020 and after October 1st, 2020, it's a 15-day notice to pay or quit. And like we said, also possibly a 3-day notice pursuant to the 1179.03 and 1179.10 and 11. Non-payment of rent after March 1st, 2021 to March 31st, 2022, it's a 3-day notice to pay or quit under the 1179.10 and 1179.11. And a new lease signed October 1st, 2021, pre-COVID rules apply for non-payment. So we go way back to that beginning slide where we're still under the 3-day notice to pay or quit. You still have to follow all of the requisite forms and the mandatory forms and whatnot. But if it's a new lease and it was signed on or after October 1st, 2021, And as Commissioner Shoker said, not a renewal, more likely an actual new lease, then that applies. Not so small claims, November 1st, 2021. So here's what was happening. The new modifications allows the landlord to sue for rental debt above $10,000 statutory limit, but the landlord could not file before November 1st and must use the mandatory SC 500. The landlord on that SC 500, the small claims form, must show, they first must make a good faith effort to help the tenant obtain rental assistance prior to filing the case, and they must attach documentation, and if there is none, describe what efforts they were taking. So the question then became, and we saw this a lot, and Commissioner Shoker can definitely speak to this, was what happened if the landlord filed in compliance with AB 3088 and SB 991, but not with their correct form? So as I said at the very beginning, all of these deadlines for recovery of rent kept getting extended. And originally under AB 3088, folks were going to be able to start applying for rent for small claims. I believe it was in March. And then sometime in the end of February, it got extended to July 1st. And then sometime around the end of June, it got extended again until September. And then it got bumped over to November 1st. But what happened was when the code was amended to allow the limitations in small claims court to be lifted, and also, by the way, the requirement that you can't file 2 or more cases for more than $2,500, that's also gone because landlords have multiple tenants. And you can also file in limited civil on these landlord cases as well. You don't have to do it in small claims. But what ended up happening was that folks, who are watching the news or talking to their lawyer friends, got a jump on filings. And so they were filing the small claims cases towards the end of the period, but with court dates set in the legally appropriate time period. And then there would be an extension and the cases were getting continued. Because when those 2 statutes went into effect, or those 2 bills were signed, nothing was ever mentioned about mandatory forms or anything like that because ERAP was not available at that. It wasn't part of what was going on. So the question then became, well, what do we do with these cases? What do we do with cases where people have already filed their small claims cases, but now they have to do this extra step? And one of the things that came up in a discussion, and it's up to the bench officers, is that it is possible and an argument could be made for a motion to file an amended, or to file an amended complaint, not a motion to, but that the party may be able to file an amended complaint with the SC 500, showing that they have done whatever it is that they need to do. They're still required to serve, but and follow everything that you would do when you normally file an amended complaint, but that their case should not be dismissed necessarily because of a fault that was not created by them. So that's one thing that the bench officers are dealing with. And I don't know, Commissioner, how many you've seen lately?
We're seeing more and more now. The ones that are lingering from a few months back, the issue there is that even if the bench officer is allowing for an amended complaint, the problem is that has to be served. So in many of those cases, the other party is nowhere to be found. So it's, those cases are kind of in a limbo that, yes, they were able to file an amended SC 500 because the court allowed them to, but now they still have to serve it because it's essentially a new complaint. So those are the things that in small claims, those are the type of issues that are coming up. Yeah. That, and you'll hear from landlords that they're willing to reapply, get the money, but if the other side is nowhere to be found, what do they do? The money's there, as Deborah said in one of the comments, that you can still apply. And by filing SC 500, that's one of the statements that the landlord has to write under penalty of perjury, that landlord has made a good faith effort to help obtain rental assistance. before they file the case. So it's one of those things where the new cases, the new SC 500 filings that are coming in that we're seeing, it's fine because they still know where the tenants are, but it's the cases that happened in that limbo period where deadlines kept getting extended. Those are the ones that are kind of hanging in there. And then this question also comes up many times, that what if the landlord didn't do the SC 500, but they're filing a declaration and they're making the same statements that are on SC 500, but they're making the same statements under penalty of perjury in a declaration form or in court. Can we proceed with the case? And again, I'll leave that up to the council, or actually not in small claim, but that's an issue that I haven't seen yet, but just trying to think around that.
It's a complicated issue, and I think that the cart was put before the horse in terms of the funding, and so I understand why the legislature lifted the limits for small claims court, because small claims is so accessible to people, especially folks who can't afford an attorney. But it wasn't, and again, it's no one could predict how this was going to play out. So it's no fault of the legislatures, but it was definitely a situation where, as we kept moving and everything kept changing, it kept affecting how these landlords were going to be able to recover their money. And also keeping in mind that although they may be during these protected periods, some of this, they may not qualify for ERAP because it may not be related to financial hardship. That may have been the claim. But the other thing to consider is that as the economy reopened and there's been a worker shortage, it's also, is there really an inability to work at this point? And what does that mean with COVID hardship? I mean, these are things that are all ripe for litigation, and we certainly don't know the answers at this time, but it was something to be considered when they're filling out these forms and going from there. So we do have some tips. One of them is to not lose hope, to write in pencil March 31st, because who knows what's going to happen in a few months. And then Commissioner Shoker, what are some of the other tips that you put on this slide?
I'm just throwing stuff that I keep seeing, as I keep stressing, using the current version of UD 120 and 125. And then the second one for UD 120, complete section 3C. And if providing attachments, make sure it's in legible font. I'm totally aging myself. I'm losing my eyesight, I think, and I cannot read font 4. And in fact, I feel better because when I hear from the clerks in the front, they come to me and say, how do I read this? What's here? So I think if people are getting printouts or something for the ERAP application or something, or an email, they just attach it and think, okay, good luck everybody, and you can read it. It just saves everybody a lot of time. If you can just make sure, if you can read it, certainly I can put my readers on and I can read it. But if you yourself cannot read it, chances are nobody else could either. And then the third issue, renewal is not, I keep stressing that. We keep seeing these issues, so that's why it went up there. And the last one is weigh the cost of delaying proceedings to the tenant as well. A delay is not necessarily in tenant's favor. The reason I put that up there is because there is people have this feeling that by delaying one side or the other, one side benefits, the other side doesn't. To me, there's a cost to both sides. What people forget is if proceedings are being delayed, the tenants get hurt as well, because if end of the day, if there's a judgment and there's a monetary judgment attached to that, now tenant is leaving the court with a huge amount of bill. And the number of people I keep seeing coming to court, they don't realize that, because the attitude out there was still, like Judge Lee said, that it was a moratorium. People thought they don't have to pay rent. And when they come to court and after a judgment, they get a judgment for $20,000, $25,000, they're shocked. There's no way in our community, people that actually really need help, they can pay the $25,000 judgment or whatever that is. So when I see, on demurrers and motion to strike and all of that, please just consider cost to both sides, because I feel like everybody's focused on one side versus the other, but there's cost to both sides. That was just my little spiel on that.
Well, I know we anticipated going to closer to 1, but seeing that I see like 22, by way of full disclosure, I was afraid to look at the chat because I don't want to see the questions. I figured that John could help us with that, but I do see that there are a lot of questions, and I know with every answer it leads to more questions. So maybe we can use some of this time to answer questions.
All right, and one last thing, like Debbie said, we do need more volunteers, attorney of the day and all of that. Not doing a plug, but Pittsburgh Courthouse is so beautiful. It is so new, and there's plenty of free parking. And
Richmond has free parking, and they have really good food nearby. And
there's a new taco shop outside. So
yeah, and you're near Target too, so you can get your errands done and help out.
Well, I would certainly agree that Pittsburgh Courthouse is a nice courthouse. I was just there the other day, and it's got a really nice, it's a nice place. So yeah, we have some questions. Do you mind if I dig into them a little bit?
Go for it.
First off is there was a question about whether the slides were going to be provided. And then I think I'll answer the second part of the question is no, Commissioner Shoker is not going to provide her cheat sheets for everybody. But I would encourage, I actually was like, duh, we should all have our own cheat sheets. If you're in the business, you should develop your own. It's complex enough here that you really do need to remind yourself of the rules. Any comment from our speakers in that regard?
I mean, I think cheat sheets are great. We can't give you any cheat sheets. This PowerPoint is just sort of an overview of how, I mean, everything in here is literally taken straight from the code. We went through the codes and we just pulled everything out and tried to condense it as straightforward as possible. So I just really encourage people to just read those code sections because that has the best information in there, and to make checklists for, in terms of what forms and everything, as Commissioner Shoker said, in your community, and Mr. Richards, in your community, it's just better to share that information.
Yeah. And there's nothing magical about my cheat sheets. It's just you cannot read my penmanship to begin with. Also, it just, once I write it down, it's easier for me to retain. So that's why I've done the list and the cheat sheets, especially over the last 6 months or so with all these changes. This is straight out of the code sections. There's nothing magical about it.
So the next question, I realize we dealt mostly with non-payment of rent here. It has to do with just cause for eviction 1946.2. And there appears that there may be a discrepancy between the notice periods on the LS Act and then taking the unit off the rental market as defined in 1946.2. Has the court, are you able to address that, or have you rendered a decision and which notice period applies?
I don't remember if it's not included, if it's, 1179.03 and all the rules that were in effect. See, this is where they didn't reconcile that's a good question. I think the answer would be, if it's not referenced in one statute and it is in the other, then that would be the one that controls, most likely.
It's an interesting issue, because they also talk, there's another issue I have before the court, so I'm not actually going to ask that question. I think you addressed this. I just want to, can we get another clarification? How is the court addressing issues with ERAP? I believe I heard Commissioner Shoker say that they're going to grant one continuance, and then if there's still no response, positive or negative from the ERAP. Can you clarify that, please?
No. So that morning, at least the way I do it, I want status of the application as of that day.
Mhm.
So if parties don't have the status, and if they're able to give me the application number, I can call the 800 number that we've been given and get a status. So it has to be provided that day. On case by case, where both sides are coming in, they have no idea, and they're okay with continuing it for one day. So we can hear it the day after, give everybody time to get call the number. I'll do that, but no, it has to be the same day. This is because the whole case is stayed. We are not, continuing the matter is not going to help anybody. So we do want the status, the most up-to-date status. So I usually recommend people that go out in the hallway and call or check online and tell me the status.
Okay. Somebody was asking if Section 8 housing is exempt from 1946.2.
I'll let Judge Lee handle that because I don't think they are, but
I think they have different requirements.
Yeah.
And you have to look at 1940, you have to look at the code and then the amendments to the code, because there was a time where there was certain things that were subject to government subsidies. There were limitations on those, but I think and I honestly, I didn't look at the codes, the updates for that specific answer. But again, I'm going to just direct everyone to go back to the statute and see what the statute says. I do know that you also have to look at the local ordinances. That the Contra Costa County ordinance that was in effect is no longer in effect. But then you have to look at the city ordinances. Like Richmond has very specific rules, and you have to follow those rules. So even if it wasn't contemplated in the statute, it may be in the local ordinance.
Along those lines, somebody was asking if UDs for non-payment for Richmond are even, if you're allowed to even file those actions at this time. Either of you have an update on that? I said
That
no
was-
because neither of you serve in Richmond, so.
Yeah, I haven't looked. Well, if you read the Richmond ordinance, what was interesting about it when they passed that emergency ordinance, it had similar exceptions that were built in to AB 3888 and SB 91. So those, you have to go back and read it, and then the question is which controls a local ordinance versus a statute. And I remember in AB 3088, the legislative intent was to sort of organize all the different statutes and sort of make it more, or ordinances, and make it more cohesive. And I believe, and I again, I don't want to misspeak, so I really encourage folks to look at the Richmond one. Richmond still allowed for non-payment of rent under certain circumstances, and they were similar. That's why it was confusing when they passed the ordinance, because it mirrored what the statute already said. So I would just tell folks to go back. I haven't looked at it in a while because I'm not there anymore. But it should comport to the current, well, actually let me take that back. The last time I looked at it, it went with the Tenant Protection Act. I don't know if it's been updated since then, but if you read it very carefully, there were exceptions for non-payment.
Thank you. Commissioner Shoker, anything to add to that?
No, what Judge Lee said.
Okay.
Let me see if I can find it.
Somebody was asking, there's the confusion about 15-day notices, 3-day notices, current forms, current language that has to be on all the notices. I have an answer for this, but somebody's asking if you knew of any forms that would be helpful or standard forms that were available for attorneys to use in that regard?
You have the answer, John, go for it.
Yeah. There's two organizations that I think are useful in that regard. East Bay Rental Housing Association, based out of Oakland, has very good forums. And I actually recommend attorneys and actual landlords to join East Bay Rental Housing Association in that regard. And California Apartment Association also has forms available. But ultimately, if you read the fine line on either of those standard forms, they say, please consult with an attorney for the exact language that should be in here. So oddly enough, you attorneys are the final, need to do your own research and figure out what forms are and what the appropriate language would be. All right, next.
And Judge Lee, we can turn off the PowerPoint.
Oh, thank you.
With regard to taking the units off the rental market, somebody was asking if they had 5 units to do a take the unit off the rental market eviction, do they have to take all 5 of their units that they own off the rental market, or could they just do one?
Are they moving into all 5 of them?
It's not an owner move in, it's a take the, it's more of an Ellis Act, take the unit off the rental market completely.
Well, again, I think that would possibly fall under prejudgment and a ruling. And so it would just depend on what the evidence was presented and any possible defense to that. So we can't really answer and tell somebody that they only have to take one off. That would fall under legal advice.
All right, I'm just gonna read the question here. Can a 60-day notice for termination of tenancy be used for properties not subject to 1946.2? So if they were exempt from 1946.2, could they serve a 60-day notice of termination of a month-to-month tenancy, I believe is the question there.
And that would fall under legal advice.
Fall under, I'm sorry?
Legal advice. We can't answer that.
Okay, can't provide legal.
But John, you can go for it.
Yeah, you are welcome to do it, but we can't give any legal advice.
Well, I believe that one of the judges mentioned earlier that everything is subject to 1946.2 at this point. But if it is exempt from 1946.2, yes, I believe you can move forward with a termination of a month-to-month tenancy with a 60-day notice. Has either speaker seen where instead of serving just a 15-day notice, where somebody served a 15-day notice for the period before October 1st and then a 3-day notice? So serving 2 notices at once, I guess. Is it okay to serve more than 1 notice? And 2, have they seen that as an effective way to serve those notices?
I can say I've seen it. I've seen 15 and 3-day notice being served. I
Okay.
cannot tell you if that's appropriate or not, but I can just tell you I've seen it.
And generally, is it okay to serve more than 1 eviction notice at the same time?
Again, I don't know if I'll be stepping into giving advice, so I'll let Judge Lee handle that.
If you look at the statute, unless there's something in the statute that precludes it or the case law, I mean, that would be always where we direct people. I will say that if anybody remembers, I'm sure people do because it wasn't that long ago, when they were serving the 15-day notices to pay or quit for the protected period where you couldn't collect rent from March 1st to August 31st, that 15-day notice had certain verbiage about the what they had to sign, for the declaration of financial hardship, and it basically advised them it was a protected period, and then included in that if they were also addressing a rent that came due after that protected period where it fell into the 25% due and owing, that was a separate notice that had separate verbiage in it, that had separate requirements. And I had seen cases where landlords filed both because the requirements were different. Even though the one signature, one COVID financial distress affidavit arguably could suffice. The notices were, the obligations under those two periods were different. So the 15-day notices had to have different verbiage in them. So that's happened.
So I would agree with that answer. And as the discussion was going on in the chat during this presentation, I had several colleagues agree with me in the same regard as serve more than one notice. We have a question here. So there's a type of eviction under CCP 1161A where there's been a foreclosure and you're evicting most likely the former owner of the property. And the question was, is to what extent do these notices that we're discussing today apply in that situation? And
Foreclosures were exempt.
yeah, so yeah, the answer is they don't. You can follow the rules of 1161A and it's a different area of law. Sorry, I've got to read, just to clarify, as discussed, this has all been in relation to residential.
Yes.
And so that are the restrictions that we're discussing lifted as far as commercial commercial tenancies going? Or do you have any comments about commercial tenancy at this time?
My understanding is these rules don't apply to commercial. So when you fill out that form and you check it's a commercial property, that you don't have, there's no ERAP for commercial property.
Right.
So, and you'll see that built into the code. It says right in the code. And again, we just ask everyone, read the code. It's read all of them. And that's why we put all the definitions up, because you'll see those definitions used specifically in each code section. And then when you get to the combination thereof, you have to read what all of those different definitions mean to kind of get there.
And also for, if you were to just read for example, UD 101, just reading the form and going through to see what's applicable to you, it walks you through those forms. So, it'll be pretty clear once you look at those forms.
I have a case that we're filing soon, and I'm literally going to take the UD 101 and interview my client one last time to make sure that we.
Right.
Any other questions, folks? I tried to decipher them all and get them all out there. If I missed you, please let me know now.
I see Deborah Levy signing off because she has to go to Martinez and do her magic there.
Thank you, Debbie.
Thank you so
Thank you,
much.
Debbie.
And I cannot even tell you how much we appreciate, like, when we get the files and they're like 10, 15 files for the calendar, and then we see Debbie's name is on the list as a mediator, then it's like, it's okay. We can finish the calendar by 11 because
Thank you.
Debbie or one of our mediators are there. So
Thank you. And it's nice to see a lot of familiar faces or names on the panel of those participants. So I look forward to seeing you guys in court. Thank
Thank you,
you.
Debbie.
Thank you.
Thank you, Debbie.
I mean, and I'm going to tell y'all the reality is it's January 21st. By the time you have this nailed, it'll be March 31st, 2022. And sometime around March 20th, or I don't know, March 30th at midnight, there'll be something else. And so, that's why we're trying to just really encourage people to read the code, break it down, make your checklists, talk to each other, because it's going to be really interesting to see what cases come out of this in terms of the Court of Appeal. And some of them at some point are going to be moot issues because we're not going to be in a pandemic forever. So this, and again, as I've said, as the economy has opened up, a lot of things are going to change. And so I don't know if these are how permanent these are. I know that they all have sunsets for like 2026 and so on and so forth, but that can also be changed. I'm not, because they keep changing everything. So we recognize the frustration, and we just ask you to be nice to the clerks. They're doing the best they can.
Yeah.
I mean, they are not trying to give anyone a hard time. They are the hardest frontline workers, and their information, remember, they're not lawyers. They don't have all the training, and they're really, really doing the best they can, as we all are.
I'm continuously impressed with the clerks in Contra Costa County, honestly. Like, They're really, really good, very professional. So
And it's amazing the work that they do. I've actually seen them at the front. They will do their best not to send something back.
Yeah.
I saw a clerk yesterday, and bless her, she went through, a file was pretty thick, and the numbers didn't line up on the judgment. And if I was doing that, I would like send it back. They need to do their math. But she painstakingly sat there, looked at the complaint, then she looked at the declaration, then she went back, looked at the notice to see what the actual rent was, what was per day. And then she turned to me and she's like, I knew you lawyers weren't good at math. So, so have patience with them. They do their best to make sure that they're not sending something back. They only send it back if they cannot fix it. So they're doing their best, and they're counting the days as well. They're hoping that nothing else comes through, and they can go back to a system where, it was familiar, but it's the same for them as well.
well, we did have it's more of a comment than a question, but they said they're, so happy with this presentation. They want to hear more landlord tenant stuff in the future. And I think if I was to summarize some things that I thought were really, really useful, one is write it down in pencil. I thought that was a really great tip. 2 is develop your own cheat sheets. And 3 is be patient with the process, because we're all dealing with a lot of change going on here. So,
And we really recognize the frustration that the landlords have felt. We get that. We also get the frustration that the tenants have felt, because when ERAP was, I went on the ERAP website. It's not easy. I looked at it. It's not easy if you are not tech savvy. You don't have access to a computer. You get halfway through the application and you're like John, and your power goes out. You have to start all over again. There are a lot of frustrations. I think sometimes when we try to make things easy, we make them hard. And so, this has been a very vexing process, I think, for a lot of people. We also recognize that there are folks that weren't paying their rent before all of this. So before all of this. And so that, COVID became sort of, they got swept into the COVID as well. So we do recognize all of the different things that are going on, and it seems like every 3 to 4 months, y'all are having to learn something new. And then so are we.
And the other thing is, even if, for example, you missed something and it just slipped through, or made a mistake, or client made a mistake or something, you can always work with the other side. And I know the mediator in me is coming out, but I've seen cases where there were issues with whether the notice or something, and they went out and came back and they said, you know what, never mind, we settled the case. And we take a big sigh of relief going, oh, good, because there were issues on both sides. So we can have updates, we can have new codes and new statutes coming up. But if the parties are willing to talk to each other, attorneys are willing to talk to each other, they can come up with their own resolution. And it doesn't matter what the law is or what's happening. This is your own private agreement that you can do. In fact, and this is not private in conversation because it was said in court, 2 counsel were talking to each other. They're like, yeah, you better mediate, because if it doesn't settle here, it'll go to Martinez for jury trial, and then they'll rake you over the coals with another mediator. So might as well have a conversation now. So
I've never
we're
heard
not
that
mean,
before.
we're just saying it works, and parties have better results if you just talk to the other side.
Yeah. And just, the hopes are that ERAP will make people whole. Like, that's what keep people in housing and make the landlords whole, wipe the slate clean and start over. And then what happens after that is out of the landlord's control. If the tenant is still not paying, then that's a different issue. Or if there's, lease violations by the landlord, that's a different story. And those are all things that can be litigated on a different day at a different time.
Well, thank you both. Thank you to Deborah Levy for her remarks and support over the years for everything that we're doing. So thank you, speakers. And I think I'm gonna hand it over to Ann for the final comments and rounding it off. Real property section, we do every third Friday, and it's going to be at noon. We're going to be doing Zooms. Next month, we have commercial leasing with Joanne Woodsum, who's a wonderful expert. We've known her for years. She's wonderful. So hope you join us next month.
Thank you, Joe.
Thank you, JR, for putting this all together. I know you did a lot of work, and thank you both, Commissioner Shoker and Judge Lee, for doing this. I know it's helpful to everyone, and does despite what you may think, I think it does calm nerves. so I think that's been achieved. So again, I will be sending out, I'm assuming I'm sending out the PowerPoint. Is that correct? As your materials?
That's fine.
That's fine. It's just from the code.
Because you said you took it right from, it's all from the
Yeah.
so
Yeah.
we'll be sending that out.
Well, Judge Lee
you're on
did
your own?
make the rockets.
Yeah.
Oh yeah, the rockets, yeah. Well, it'll be a PDF of the PowerPoint. So we'll be sending that out, and we look forward to the real estate section's robust programming for the rest of the year as well. And we'll see what we can do about some more landlord tenant programs going forward as well. So thank you all very much, and have a
Thank
great
you.
weekend.
Bye.
Adios.
Thanks.